5 seconds to go. Start. The averments and the documents placed before us, we may record a prima facie view that the respondent tenant has, for the reasons yet undemonstrated, been delaying the payment of rent and or other dues payable to the petitioner applicant landlord. This denial of monetary benefits accruing from the property, when viewed in terms of the unchallenged market report forming part of the record, is undoubtedly substantial, and as such subject to just exceptions. We pass this order for deposit of the amount claimed by the petitioner applicant to ensure complete justice inter se the parties. After all, we cannot lose sight of the fact that the very purpose for which a property is rented out is to ensure that the landlord, by way of the property, is able to secure some income. If the income remains static over a long period of time, or in certain cases, as in the present case, yields no income, then such a landlord would be within his rights, subject, of course, to the agreement with their tenant to be aggrieved by the same. The factors considered by us have been referred to in Martin and Harris Supra. We are supported in our conclusion by the observations and guidelines issued by this court in Muhammad Ahmad and another versus Atma Ram Chauhan and others. We reproduce the onus relevant to the adjudication of the present dispute herein below. According to our considered view, majority of these cases are filed because the landlords do not get reasonable rent akin to market rent. Then on one ground or the other, litigation is initiated. The tenant must enhance the rent according to the terms of the agreement, or at least by 10% after every 3 years, and enhanced rent should then be made payable to the landlord. If the rent is too low in comparison to market rent, having been fixed almost 20 to 25 years back, then the present market rate should be worked out either on the basis of valuation report or reliable estimates of building rentals in the surrounding areas let out on rent recently. Apart from the rental property tax, water tax, maintenance charges, electricity charges for the actual consumption of the tenanted premises and for common area shall be payable by the tenant only, so that the landlord gets the actual rent, out of which nothing would be deductible. In case there is enhancement in property tax, water tax, or maintenance charges, electricity charges, then the same shall also be borne by the tenant only. If the present and prevalent market rent assessed and fixed between the parties is paid by the tenant, then the landlord shall not be entitled to bring any sanction for his eviction against such a tenant, at least for a period of 5 years. Thus, for a period of 5 years, the tenant shall enjoy immunity from being evicted from the premises. The parties shall be at liberty to get the rental fixed by the official valuer or by any other agency having expertise in the matter. The rent so fixed should be just, proper, and adequate, keeping in mind the location, type of construction, accessibility to the main road, parking space facilities available therein, etc. Care ought to be taken that it does not end up being a bonanza for the landlord. Since the special leave petitions are pending adjudication, we make it clear that directions made in the above stated interlocutory applications herein are subject to the final outcome of the former, keeping in view the location of the demised premises, the rent as agreed, the alleged non-payment of rent, the default in payment of interest as alleged, and other such like factors, we are inclined to accept the calculation of dues as made by the petitioner applicant submitted to this court during hearing as reproduced herein above. Stop.